In my opinion, the most insidious of moves that is currently being perpetrated in our legal system by various, shall we say, anti-American, anti-freedom, anti-Second Amendment factions within our society is the assault weapons ban. You know, the weapons of war that don't belong on our streets type movement. And I think that the reason that I find this one quite frankly disgusting is that it flies in the face of the whole reason the Second Amendment exists. It does not exist to protect your right to shoot ducks and deer. It is there for self-preservation, whether we're talking macro scale, like the founders were really concerned about when they wrote the Second Amendment, having just come off of a major conflict against a world superpower, or whether we're just talking about trying to keep a meth head from breaking into your house in the middle of the night and killing you over the $10 in your desk drawer. Those two things are argued about consistently in our society today on whether they are relevant today. You know, we are so progressive that we have moved past the need to bear arms to take care of ourselves because we are such an enlightened society. The difference is that we have power. We have utilities. There are things that keep society functioning. The rule of law exists. But you need not look very far into the imminent past to figure out what happens when those services go away. The bottom line is that those two pillars of the Second Amendment are not actually pillars. They are goalposts, and there's a spectrum of protected conduct in between. And that protected conduct goes something like this. You are a human being. And by the nature of being a human being, you are endowed by your creator, whether you believe that or not, with the inalienable right, inseparable right to defend your life and the lives of those that you care about against evil, against harm, whether that is being perpetrated by your government or whether that is being done by some rogue citizen or foreign national. The Second Amendment exists to ensure that the government doesn't get in your way in that effort. And I don't think that there is a more apt example of the government interfering in people's ability to defend themselves than to ban commonly used across the world weapons because of some characteristics that they don't like, that they say are scary and are militaristic and don't belong on our streets. The concept that the government knows better than the individual citizen who is the person who is actually going to be using the thing. They know better at what works best for that individual is as big an about face on American tradition as you could consider. Especially when you consider that the government literally gives those same guns to the agents that they tell to go out and enforce the law, and the purpose for them to have a weapon is to defend themselves. The hypocrisy is amazing. The cracks, however, are formed and are widening. The current battle as it pertains to so-called assault weapons bans is out of the state of Illinois. And that's what we're going to be talking about here today because we have a little bit of an update on the situation there on the ground as it pertains to the court battle. The anti-gunners are desperate. All they can really do is hope to stall as long as possible and hope that the makeup of the Supreme Court of the United States changes. Because as it currently sits, they stand to lose and lose big. And that's what we're going to be talking about in today's video after we hear a quick word from today's sponsor. A lot of houses just have like a rudimentary first aid kit that's not good for like serious injuries. And even if you don't know how to use things like chest seals and tourniquets and stuff like that, having those supplies on site when somebody who does know how to use those things, like particularly when we're talking about incidents like this where people are being rescued from disaster areas, having those supplies there and not having to have them take up the supplies of the emergency personnel that are going to have limited resources when they get there is a very, very important concept, and one of those responsibilities that, in my opinion, we should all take. So Medical Gear Outfitters is my go-to place for that sort of stuff. I know the people who own the company and do the stuff on the ground, putting the stuff in the boxes, and they even have one now that is in a Pelican case, which straight up existed before the hurricane hit. Just going to make that very clear. They're ready to go out the door for anybody who wants to have that little extra level of preparedness, specifically when it comes to medical equipment. So special thanks to Medical Gear Outfitters for making today's video possible, and they offer you guys a discount code. You can find that information listed in all of our relevant places. I'm going to give you a real quick lay of land so you know where we are and where we've been and where we're going type thing. So as it pertains to the challenges, the legal challenges, the suits, if you will, against Illinois' so-called assault weapons ban, there are multiple challenges, and they are currently sitting at the district court level. Now, that's fairly nuanced. An injunction was issued by the district court judge, Judge McGlynn, but that was appealed up to the Seventh Circuit. The Seventh Circuit reviewed that, and they said, we don't really like that, and threw it out. That was then appealed up to the Supreme Court, and the Supreme Court looked at it and said, hey, we don't take cases on interlocutory posture, which means that if it's not our turn, we don't step in. And then they sent it all the way back down and said, hey, redo it looking at these precedents. But in that, Clarence Thomas wrote a very strongly worded warning to the Seventh Circuit and the lower courts, who will ultimately review it again before it gets back to them. And let's hear what Clarence Thomas said. Petitioners sought a preliminary injunction against the enforcement of the law, arguing that the law violates the Second Amendment right to keep and bear arms. The Court of Appeals for the Seventh Circuit rejected the petitioner's request for preliminary injunction, concluding that the AR-15 is not protected by the Second Amendment. According to the Seventh Circuit, the rifle selected by millions of Americans for self-defense and other lawful purposes does not even fall within the scope of the arms referred to by the Second Amendment. This court is rightly wary of taking cases in an interlocutory posture. But I hope that we will consider the important issue presented by these petitions after the case has reached final judgment. We have never squarely addressed what types of weapons are arms protected by the Second Amendment. To be sure, we explained in the Heller decision that the Second Amendment's protection extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And we noted that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, recognizing the historical tradition of prohibiting the carry of dangerous and unusual weapons. But this minimal guidance is far from a comprehensive framework for evaluating restrictions on types of weapons, and it leaves open essential questions such as what makes a weapon bearable, dangerous, or unusual. The Seventh Circuit's decision illustrates why the court must provide more guidance on which weapons the Second Amendment covers. By contorting what little guidance our precedents provide, the Seventh Circuit concluded that the Second Amendment does not protect militaristic weapons, and then went on to tautologically define militaristic weapons as those that may be reserved for military use. The Seventh Circuit's contrived non-militaristic limitation on the arms protected by the Second Amendment seems unmoored from both text and history. And even on its own terms, the Seventh Circuit's application of its definition is nonsensical. No army in the world uses a service rifle that is only semi-automatic. In my view, Illinois' ban is highly suspect because it broadly prohibits common semi-automatic firearms used for lawful purposes. It is difficult to see how the Seventh Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. That is what they are up against. And they know that when they eventually get up to the Supreme Court, that if the court looks like what it currently looks like, that they're going to get their butts handed to them. And the Supreme Court basically just said, hey, look, we think that y'all really suck at interpreting what we've been telling you for all these years. We thought that we laid out some pretty easy to follow guidelines on what's protected by the Second Amendment, basically everything. Y'all seem to be ignoring that and going your own direction, doing your own analysis that is completely divorced from what we've been telling you to do. So go ahead and bring it back to us when it's our turn, and we'll tell you precisely what is protected. Hint, hint, you're probably not going to like the answer when you come back, so you best do your job pretty good when you come up through here, so we don't really have a whole lot to nitpick, because we will. Well, the most recent perpetration, if you will, by the state of Illinois was to flood the court with piles of documents to slow the case down. So basically, Judge McGlynn said, hey, I feel like I'm still going to say what I said last time, but you know what? Y'all go ahead and submit me all the evidence of a historical regulation that would mimic something that the state of Illinois is trying to do. And the state of Illinois responds by dropping 3,500 pages of documents on him. So what they are trying to do is get the judge to spend some weeks reading through all that stuff so that hopefully they can push this, because remember, the Supreme Court operates on terms. So by delaying a few weeks here or there, they can try to shift it out to a future Supreme Court term. Because remember, the Supreme Court operates in a block, and then they release their decisions, and then they operate in the next block. And as it currently sits, it's definitely not happening on this term. It's not probably going to happen on spring term for the Supreme Court. But it probably, depending on how the timeline might operate, might make it on fall 2025 term. So when you're considering that and you're trying to push this out as far as you can, from their perspective, delaying a week here or a week there, or, just dragging their feet, not doing their homework and asking for an extension like we've seen in multiple instances, that has the net effect of maybe being able to push that Supreme Court hearing out to maybe spring 2026. You see what the process is here? So that means that we wouldn't get a decision, like an actual opinion, until fall of 2026, or maybe even later. So the long game that they're trying to play here is we just have to stall. And again, in my opinion, the most insidious thing that a government can do is say, hey, this thing is good enough for our people to defend themselves, but you, the citizen, the chaff, the chattel, the serfs, you don't need that. Even though that might be the best tool that you could possibly use. And in my opinion, the AR-15 is the best home defense tool conceived by man for its self-defense. That's all I got for you guys today. Sound off in the comment section down below. Let me know what you guys think. And hopefully we'll have an update on this thing for you pretty soon. Hopefully Judge McGlynn says, yeah, this is all a bunch of bullshit. I'm going with what I said last time.